We're going to call Vanita Lloyd versus Lamar Lawrence. Case number C22G2833. Who's here on this?
Anthony Lupkin for Miss Lloyd, plaintiff.
Okay.
Never showed. Guy never showed.
Is Lamar Lawrence here?
He never showed. He's 6 hours late.
Okay, well, let me see here.
It's termination. We're not waiting for money. Should be able to be pretty easy to just dispose of it. This guy's majesty.
Imagine showing up to court 6 hours late and thinking you still have a case. The judge doesn't mince words here. If you can't even bother to show up, why should the court take you seriously? Already, this tells us a lot about how the rest of the hearing is going to go.
Well, I don't have a real way of verifying that, because I've had a swap of court recorders in the middle of the day.
If he cared, he would have come in the middle of the day and he would have checked in and waited for the new court reporter. So either way, he's a dud.
You know, Mr. Lupkin?
Yeah?
I got to tell you, the case is...
Well, you know, if you want to blindside me with some scolding, I'm ready. I don't know what the heck's wrong with it. I don't appreciate always having bad news all the time.
Turn to your notice to quit.
Yeah?
See it?
Yeah, what about it?
Paragraph 1. They either have to check the box that refers to the statute, or they have to check the box that says other and fill in that blank.
I think she checked the box. Maybe it came out too faint. Maybe she used a Sharpie. A yellow. I mean, I understand like the punished landlord. This nice old lady. She's a you know, nice church going black lady. She's everything fair and square. She doesn't cheat anybody. She's a sweetheart. And you know, you slam everything landlords make mistakes.
I like to follow the law, Mr. Lupkin. Well, the law is that if the notice to quit or demand for possession is defective, then the court does not have jurisdiction to hear the case. So that's what the law is in Michigan, and I don't care.
This is where it gets really interesting. Even though the tenant didn't bother to show up, the law doesn't just let the landlord win by default. If the paperwork isn't filled out correctly, even something as small as a blank checkbox, the court technically has no jurisdiction. That's not nitpicking. That's due process. It protects people from being kicked out of their homes unfairly.
She's the one who sent the notice. She has to know that.
Well, you're going to show her that she didn't check a box, right?
Well, if you say in your notice, relief denied for lack of checking off the box on number 1, you know, that'll be good. I hate to have had to wait 6 hours to find out something like this. So I was like, why can't they, do the quickies first and argue with people about their guardianship and their mental problems and their autistic children through the day? You know, this is something I shouldn't have had to hear all that daytime TV this out. It'd be different if we had success after 6 hours, but much as I like you, I like your sense of humor. I know you're very thorough. Why can't you go through all the easy stuff and weed these out and then, you know, slap us with the dud news early?
You can feel the lawyer's frustration. He waited all day only to lose on a technicality. But this is the reality of landlord-tenant court. It moves fast, it's unforgiving, and judges are sticklers for procedure. The judge even jokes about retirement here. But behind the humor is a serious point. Landlords can't afford to be sloppy with the law.
Over at the community college, when people take a test and they fill in the bubbles, you know? So maybe I'm just kind of like a machine. If the right bubble isn't filled out, well, they're marked wrong on the test.
But the problem is that if there's no one there,
that could be.
Normally, the judge isn't the advocate for the absent guy. You know, if the guy doesn't show up, you can say you don't have jurisdiction, but actually, you have jurisdiction. It's just technically not filled out right. It's up to the absent guy or his lawyer. Or
it's not filled out right, which means, well, let me flesh that out.
You can decide how you want.
It's not filled out right, which means as to the purpose for wanting termination. The whole giving somebody a notice to quit or a demand for possession is for the landlord to be able to say to the tenant, hey, you didn't pay your rent. Here's how much you owe for a non-payment case. And of course, in a termination case, the notice is to say, here's why I'm kicking you out, or here's why I want you to leave. And that will correct this behavior in a termination case. You can stay. Or if you pay that amount of money, you can stay.
I love how the judge explains this. The notice to quit isn't just paperwork. It's how tenants are told why they're being evicted. Without that, they're left in the dark. This isn't about punishing landlords. It's about basic fairness. If you don't tell someone the reason you want them out, how can they defend themselves?
Yeah, well.
Notice requirements can be conceived of as two distinct conditions that must be met before the landlord may commence proceedings. The first condition is that the landlord information about his or her intentions to the tenant in a specified manner. That would be letting them know why you're trying to kick them out. The second is that they wait a specified time period.
Okay, but in that case, in Park Forest case, the defendant got notice to terminate, then they accepted rent afterwards. That was the problem. Nothing to do with this case. No one's accepted any rent afterwards. Not to mention the fact that
Park Forest.
I'm reading it.
Well, there's a whole lot of things that Park Forest talks about. I got to move on, Mr. Lipton.
I'm just saying that.
But you got 21 days to appeal my decision.
This judge makes it clear. This isn't a one-off ruling. He dismisses cases like this all the time. Consistency is important in the law, even if it feels harsh in individual cases. If you're a landlord, you need to get these details right, or you'll keep losing.
What's your name?
Requill Person.
Spell.
It is spelled Requille. Last name Person, Person.
Defendant.
Jacqueline Johnson.
Okay, so Mr. Jennings, Miss Johnson moved in my property a little over a year ago, and we agreed that the rent will be $750. The state of Michigan pays $690 of her rent, and for the first 4 months, Miss Johnson paid me the remaining balance, which would be $60 of her portion. And for the past 11 months, I have not received no payment from Miss Johnson.
Well, have you applied for assistance, Miss Johnson?
No, because my rent portion is $690 and I don't pay a portion. And my rent is paid through Becca Management. It's a Section 8 program.
So what's the issue? Why isn't it paid?
My rent is paid. My rent is paid by Becca Management every month. $690.
And here's the shocking part. The very next case has the same exact problem. Two landlords back to back, both tripped up by the same defective notice. It's almost like watching history repeat itself in real time.
Ms. Ferguson?
Yes, sir.
Do you have your notice to quit in front of you?
Yes, I do.
You got the same issue as the last.
What you said, what is not filled out correctly, Judge?
It is not. Look at paragraph 1 on your notice to quit.
Okay, when I went down there to fill it out, the clerk office actually helped me fill it out. So then we need to adjust that with the clerk office if they are going to be assisting us with filling out paperwork to fill it out correctly.
No. Number one, they're not supposed to be giving legal advice. And there's a big blue sign that says that, okay? Now, if they're giving legal advice, I guess that you need to tell me who you talk to so that I can, ask their supervisor about that.
Okay, so what do I need to do from here?
Besides that, giving her the notice to quit before you came down to the courthouse to file the action?
Yes, I did. I gave her a 30-day notice before then.
Yes, you did on May 5th, right? So when did you say that the clerk told you how to fill this out?
I said they assisted me on filling it out the correct way, sir. I didn't say they told me how to fill it out. They never gave me legal advice. I'm sorry, they assisted me on filling it out.
Well, I don't know exactly what you mean. I don't know exactly what that means.
Okay, so what exactly was wrong with it, sir?
Okay, paragraph 1. You see it says, your landlord, landlady, your name, is seeking to recover possession of property pursuant to, in the next line, you have left blank to explain why you are seeking to recover possession of property. So either you check the box that refers to the statute, or you check the box that says other and you write in the reason.
You can hear the frustration building. The landlord even says the clerk helped him fill it out, but the judge shuts that down quick. Clerks can't give legal advice. At the end of the day, it's the landlord's responsibility. This is another reminder. Courts don't bend rules just because someone's inexperienced.
You see what I'm talking about?
Yes, sir.
You're not going to tell me that one of the clerks told you to leave that blank, are you? So it's blank because you didn't fill it out. Is
Correct.
that true?
That is true.
All right. Because the notice to quit is defective, the court doesn't have jurisdiction to hear the case. And I cited the law on that earlier, but if you want me to go through it again, I can.
Not at all. I've just filed another one.
The other thing I would point out, and this is not, I don't see a copy of the lease attached. Check out your complaint. You see your complaint?
Yes.
You see paragraph 2 of the complaint?
Yes.
It says attached is a copy of the lease or occupancy agreement.
Yes.
Well, you're supposed to attach a copy of that. You're supposed to server to server. Okay?
Okay.
All right.
Have a great day.
All right. We'll see you.
And finally, the knockout punch. Not only was the notice wrong, but the landlord also failed to attach the lease. 2 mistakes, both fatal. And just like that, the case is dismissed. If there's one takeaway here, it's that housing law isn't casual paperwork. These cases impact people's homes, so the law demands precision,